Do you know the difference between a will and a living trust? Let's delve into these two key terms. A will, simply put, is a legal document that outlines how you'd like your assets distributed after your death. A living trust, on the other hand, is a legal entity you create during your lifetime to hold your assets. This video will explore the distinctions between the two and guide you in determining which best suits your needs. Stay tuned to understand these two important elements of estate planning. A will, also known as a testament, is a legal document that expresses your wishes after your death. It's essentially a roadmap that guides the distribution of your assets, ensuring that your possessions end up in the hands of those you've chosen. Creating a will involves detailing your assets, identifying beneficiaries, and appointing an executor. This trusted person is responsible for carrying out your wishes, navigating the probate process, and ensuring a smooth transition of assets. But what if there isn't a will? In such cases, the state steps in and the assets are distributed according to intestacy laws, which may not align with your preferred allocation. A will is also unique in its ability to name guardians for minor children, a feature not available in all estate planning tools. However, it's important to note that a will does not bypass probate, a court-supervised process of distributing assets. Remember, a will becomes effective only after death. On the other hand, a living trust is a legal entity you create to hold and manage your assets. It's like a secure box where you place your assets with the key held by a trustee. You, as the grantor, can also act as the trustee, managing your assets for the benefit of the beneficiaries you've named. Creating a living trust involves drafting a trust agreement, transferring assets into the trust, and periodically updating the trust as necessary. The living trust stands out for its unique features. For one, it avoids probate, the often lengthy and costly court process of validating a will. This means assets can be distributed to beneficiaries more quickly and privately. Secondly, a living trust provides for incapacity. If you become unable to manage your affairs, the trust remains in place, and a successor trustee can step in to manage your assets. Unlike a will, a living trust can start benefiting you during your lifetime. Now that we understand what a will and a living trust are, let's delve into their differences. First up, when do they take effect? A will only becomes active upon your passing, while a living trust starts working the moment it's created. This means with a trust, you can start distributing your assets while you're still alive if you wish. Next, let's consider privacy. A will becomes public record once it goes through probate, which is a legal process to verify its authenticity. On the other hand, a living trust remains private, keeping your affairs away from prying eyes. Now, onto cost and complexity. Crafting a living trust generally requires more time and money up front than preparing a will. However, it may save your beneficiaries time and money in the long run by avoiding probate. Speaking of probate, a will must go through this process, which can be lengthy and costly. A living trust, meanwhile, bypasses probate, allowing for a more efficient distribution of assets. Lastly, in terms of control over assets, a living trust allows for more flexibility. You can specify terms for how and when your beneficiaries receive their inheritance. In contrast, a will offers a more direct but less flexible distribution of assets. In conclusion, the choice between a will and a living trust depends on your personal circumstances and estate planning goals.